What happens when the grantor dies? Okay, what am I talking about? What is a grantor? Typically, when you hear the term grantor, that is the person who has created a trust. They're also called the trustor. They're the person who, for example, created a revocable living trust. And it could be, the grantor can be a single person, it can be a married couple. They set up their estate plan with a revocable living trust. The reason that they did that likely was so that they would avoid the need for a probate on the death of the grantor. So what happens now that the grantor has died? Let me tell you what should happen and what often happens. So the grantor has died. The successor trustee, the person who comes in to manage the trust after the grantor's death, let's say the grantor was also the first trustee. That's possible. Maybe they were, maybe they weren't. But the trustee, who is either the successor trustee or somebody who is now managing the trust, needs to go talk to a lawyer. Because if you've seen trusts, they can go from 3 to 5 pages to literally 100 pages. Who is supposed to understand what this trust means? They are very dense sometimes. Don't expect that you, as the trustee or successor trustee, should be able to interpret what this trust means. Instead, go see the attorney. See the attorney who drafted it if they're available. If not, seek out an elder law attorney. So you go to the attorney once the grantor has died and you say, help, what do I do next? The attorney is going to give you directions. Those directions could be very simple to say, this was a single person who was the grantor. Now that they've died, they want everything in this trust to divide out equally to the 3 children outright. That's your job, trustee. I'll help walk you through that. Or it could be a little bit more complicated. Maybe the grantor was a married person that the spouses created this trust together. Now one of the spouses has died. What's going to happen next? Again, if the surviving spouse or the successor trustee goes to the attorney, then they are going to make sure that this trust is properly implemented, because there are actions that need to be taken after a grantor dies, especially with a couple. Lots of times, revocable living trusts, once the grantor dies, they're set up such that the deceased spouse's share now goes into a new trust. It's an irrevocable trust. It will have its own tax ID number. It no longer will work to use the grantor's Social Security number. And then perhaps the other half of what was in that original revocable living trust goes into the survivor's trust. And that can still use the survivor's spouse's own Social Security number. So now you have at least 2 trusts going on. And one of the reasons to use this irrevocable trust is to capture estate tax credit exclusion amounts, particularly important in states like Washington, where our estate tax exclusion amount is only $2.193 million, in contrast to the federal, where it's over $12 million, much higher. So that's what should be done. That's what was intended to be done. What do people often do? Well, because let's say the house is already in the trust and maybe it's a surviving spouse and they don't have any urgent need, there's nothing compelling them to go see a lawyer, and they remember that they were supposed to go see a lawyer, but they couldn't remember why, and they don't want to reach out to the lawyer because they don't want to have to pay the lawyer anything more because they already paid the lawyer, so they just don't do anything. What happens then? Well, all of these trusts that should have been created, that tax protection trust, was never created. Everything is simply owned by that surviving spouse because that surviving spouse never properly implemented the plan because they didn't seek out guidance. In the state of Washington, that can be a really bad result. Let's say that the couple had $4 million and 2 of it was supposed to go in this tax protection trust when the first grantor died, but it never did. So a surviving spouse basically has ownership and has $4 million. What's going to happen when surviving spouse dies? Well, there's going to be an estate tax on just about $2 million. That's hundreds of thousands of dollars, all of which could have been avoided had the surviving spouse, the successor trustee, said, let me just contact that lawyer and find out what we should do. So if you are in that situation where there's been a grantor who has died, it's a family trust or a spousal situation, please see an estate planning and elder law attorney. You'll be glad you did. It can save you tens of thousands, if not hundreds of thousands of dollars.